This is just a brief introduction into what being a Rule 6 party to an inquiry entails. There's a lot more information on this on gov.uk, and you can also contact the Planning Inspectorate's case officer, and their contact details are set out on the appeal start letter. So if you have a particular interest in an appeal that's proceeding by means of an inquiry, you can take part as a Rule 6 party. Rule 6 parties are usually a local group or organisation, maybe a local business, parish council. They're not usually individuals. The benefit of being a Rule 6 party to the inquiry is that you will be a main party to the event with rights and responsibilities. The reference to Rule 6 is taken from Rule 6 of the Inquiry's Procedure Rules, and there's plenty of guidance on that on gov.uk. As a Rule 6 party, you're entitled to take part in the inquiry proceedings, preparing and presenting your own evidence, and interrogating the evidence of the other parties to the inquiry on the side that you oppose. There's no cost to being a Rule 6 party to an inquiry, other than the costs you may incur yourself involved in things like printing, binding documents together, posting documents, and of course any costs you might incur in attending the inquiry event itself. Depending on whether you support or oppose a development scheme, you may wish to consult with the local planning authority or the appellant to establish what their position is likely to be at the inquiry. If that coincides with what you want to say, it may be that you don't need to apply for Rule 6 status at the inquiry and that they would represent your position for you. If you do think you want to be a Rule 6 party to the inquiry, it's important that you write to the Planning Inspectorate's case officer as soon as possible, preferably within 5 weeks of the start of the appeal, setting out that you wish to request Rule 6 status. You will need to set out your interest in the appeal and the appeal proceedings and provide a general outline of the case you want to make at the inquiry. It doesn't need to be all the details at this stage, just a brief overview of your statement of case. Provided you seek Rule 6 status sufficiently early on in the proceedings, you'll be invited to take part in a telephone conference. That telephone conference takes place 6 to 7 weeks after the start of the inquiry. It's led by the planning inspector, and other parties to the conference are the council and the appellant. The conference deals with procedural and administrative matters. Among other things, the inspector will set out how the evidence will be dealt with, what the likely main issues are, and will also set out a draft running order for the event itself. As a Rule 6 party, you'd be copied in to all the other documents that are provided by the other main parties. You would also need to provide your own evidence in accordance with the set timescales. So that would be your proofs of evidence, which set out each aspect of your case in much more detail. In terms of timescales, the inquiry itself would open in weeks 13 to 16 after the start of the appeal, and your proofs of evidence would need to be submitted at least 4 weeks before the inquiry opens. Although you should attend the inquiry on the opening day, there's no need necessarily to attend every single day of the inquiry. You will, however, need to have agreed in advance with the inspector how and when you will be presenting your evidence, and obviously you would need to be present at the inquiry on those days. And also, if you want to interrogate the evidence of other parties and examine that, or take part in the roundtable discussions, you would need to be present on those days as well. Although there's no requirement for anybody to be legally represented by a solicitor or a barrister at an inquiry, it's customary for each of the main parties, including Rule 6 parties, to be represented by an advocate. Their role is to present an opening for you as the Rule 6 party, to take each of your witnesses through their evidence and to ask questions or cross-examine of the evidence of the other parties. They would also provide a closing statement summarising your case as it stands at the end of the inquiry. When advocates are inexperienced, the inspector will assist and provide guidance on the procedures to be followed. If you don't have an advocate, one of your witnesses can act as an advocate for you, and they can ask questions of the witnesses on the other side, but they'll also have to take themselves through their own evidence that they present to the inquiry. If you do not nominate someone to be your advocate, then you would need to introduce yourself to the inquiry and present your own evidence without somebody taking you through it. I mentioned earlier that there was no cost for Rule 6 parties taking part in an inquiry. However, all parties to an inquiry, including Rule 6 parties, are required to behave reasonably. That includes providing all your evidence in accordance with the set timescales and things like not introducing new evidence very late in the day. If a party, including a Rule 6 party to an inquiry, does behave unreasonably, and where that behaviour results in another party to the inquiry incurring unnecessary or wasted costs, for instance producing unnecessary evidence or calling witnesses that weren't needed, then you might be liable for those costs. I would stress, however, that just being a Rule 6 party at an inquiry is not of itself unreasonable behaviour. The relevant section in the Planning Practice Guidance on gov.uk provides a lot more information about that, but provided your behaviour is not unreasonable, then any application for costs against you would not succeed.